Welcome back. So we've got through in the last segment, we got through plea bargaining and a lot of the preliminary parts of a trial. We've had a little section off camera about pretrial motions. These are, of course, motions that occur prior to a trial. Once the trial if we're going to make the decision, if plea bargaining doesn't happen, and we make the decision that we're going to go ahead and have a trial, then we've got to select a jury before we can start a trial. So we open this segment talking about jury selection or the process known as voir dire, which is Latin for to speak the truth. So how big does a jury have to be? Now, this is something that varies by state. Most states use 12-person juries. Some use 6 or 8-person juries. The use of a 6-person jury was upheld by the Supreme Court in Williams versus Florida, though in Bayou versus Georgia, the court ruled that a 5-person jury is far too small. In Texas, we use a combination of either 6 or 12-person juries, depending on the seriousness of the case. Now, jury size does affect verdict voting. For 12-person juries, non-unanimous verdicts are okay in most cases, though not in capital trials. But smaller juries, so any jury with less than 12 persons in it, must be unanimous in order to convict a defendant. So who can be a juror? What are the qualifications to be a juror? Again, varies by state, but there are some common standards, such as individuals must be U.S. citizens of age 18 or older, residents of the court's jurisdiction. They must have sufficient knowledge of the English language and no felonies, though some states also exclude for certain misdemeanors. For example, in the state of Texas, if you have been convicted of a theft-related misdemeanor, you are not eligible for jury duty. So how do you get jurors? Well, first you start with something called the jury pool, which is a big list of names of eligible jurors. Now that's created in different ways in different jurisdictions. Some jurisdictions use voter registration rolls. For example, Texas does it that way. When you register to vote, you also become part of the jury pool in the county that you registered for vote in. Some use driver's license records. States used to use telephone directories, but since the popularity of cell phones, that's no longer an option, considering that there's a lot of people, say for example, living in Nacogdoches like myself, that our home cell phone uses a number, an area code from a different area. So once you have the jury pool, you're going to select a certain amount of potential jurors from the jury pool for a particular trial. And the size of the jury pool really depends upon the seriousness and the complexity of the case. Those people will receive notices in the mail. The notice will generally include some sort of questionnaire. And the questionnaire usually involves the state approved exceptions for jury duty. For example, when I was a much younger person, I gained a conviction for theft by check, and which makes me ineligible for jury duty in the state of Texas. And so when I get a jury summons notice, I just click the box that says I have a conviction, I have a theft conviction, and that I'm not eligible for jury duty, and I send it back in by the date imposed. I think there was one time I forgot to send it in on time and actually had to show up and tell the court clerk, hey, I'm not eligible for jury duty. Then I asked if I could still sit in. They told me no. What happens? You make dumb decisions when you're youthful. And then so you bring the jurors into the room. The judge will ask general questions. In fact, in some states and the federal system, the judge does all the questioning during voir dire. And then both sides, prosecution and the defense, can give the judge questions they want to ask. But then there are some states where the judge will ask general questions, and then both the prosecution and the defense can also ask the potential jurors questions. Now, the purpose of voir dire is to eliminate impartial jurors, because to eliminate partial jurors or biased jurors. The idea is that you question, the judge questions the jury pool, Both sides in some states will question the jury pool, and the legal technical purpose is you're removing jurors from the jury pool that would have some bias against the defendant or for the defendant. And you're going to limit them from the jury pool so that you get a fair, impartial jury. During the process, either side in a case can challenge prospective jurors. And by challenge, I mean they say, okay, I want to throw that person out of the jury. I want to remove that person from the jury pool. And there are two types of challenges. There are challenges for cause. Challenges for cause are those challenges established by law. So if you go to the Texas Penal Code, you can find those challenges for cause that are permitted in Texas. Legitimate reasons you can tell the judge, okay, I want that person excused from the jury pool because they've been convicted of felony, because they have this, that, and the other thing. That is a legal reason established by law to eliminate this person from this jury. In capital cases, the court has ruled that potential jurors can be removed if their belief system is such that they would automatically vote for an acquittal because of their beliefs in the death penalty, or their belief in the death penalty would prevent them from being unbiased in decision making. You cannot, however, be removed from a jury pool for cause just because you oppose the death penalty. So the judge or party asks you, how do you feel the death penalty? And someone like me would say, I'm opposed to capital punishment. And then the follow-up question is, could you follow the law despite your disapproval of the death penalty, your opposition to the death penalty? Someone like me would probably say nope. And I would say, well, I'm never going to vote, especially in the sentencing phase, which is a whole new jury. I would say I'm never going to vote for execution. I'm always going to vote life without the possibility of parole. So, in the guilt innocence phase, yeah, I'll vote to convict the guy, even though I'm opposed to death penalty. But if you carry me over into the jury pool for sentencing, I will never vote for execution. I don't care what you tell me. I'm always going to say life without the possibility of parole. So I would probably, even if I was actually eligible for jury duty, I would say, well, I would be excused for cause. Now, the other type of challenge is a peremptory challenge. These are challenges without cause. And each side gets a limited number depending on the type of the case. So the more serious the case, the more challenges, the more complex the case, the more serious the case, the more peremptory challenges you get. The less complex or the less serious the case, the fewer peremptory challenges you get. This is the number of peremptory challenge, of course, is established by law. And with peremptory challenges, you just say, Your Honor, I wish to use my peremptory challenge on juror number and so. And the judge goes, you're excused. And there's no question, there's just that person's out. There are two exceptions to peremptory challenges. Peremptory challenges cannot be based on race. In fact, there's a famous Supreme Court case, Batson versus Kentucky, which says you cannot excuse a juror simply because of their race. And then JEB versus Alabama says you can't excuse someone from a jury simply because of their gender. And so what would happen, the way this would work in the process is that one side or the other would say, okay, Your Honor, I wish to use a peremptory challenge on juror number 4. The other case would stand up, objection, Your Honor, Batson challenge. And that's the other side's way of saying, if I say I wish to file Batson challenge, that's my way of saying, okay, I think the other side, I think that they're excusing this guy just because he is named racial group. And then it comes back to the side that issue the peremptory challenge. They then have to tell the judge, okay, this is why I wish to remove this person from the jury pool. And you basically have to convince the judge, I'm not removing him because he's black. I'm removing him because I think he would be partial to the defense or partial to the state. You just give some reason. The same thing with gender, only it's not a Batson challenge. You just gender challenge or whatever. All right, once the jury is set, you're going to have a trial. Sometimes the defendant either before voir dire, sometimes after voir dire, will waive his right to a jury trial. This cannot be done in a capital case. Note that in a capital case, the defendants cannot waive their right to a jury trial because the Supreme Court has ruled that a judge by himself cannot issue the death penalty. And so at the very least, the sentencing phase of a trial, defendant cannot waive his right to a jury trial. But defendant may waive his right to a jury trial. Say, I don't want a jury, I want the judge to decide. And there's a variety of reasons. Some defendants feel they'll receive some consideration if they save the court's time by not invoking the right to a jury trial, especially if they waive their right to a jury trial before voir dire happens. The defendant may fear the jury because it's an emotionally charged case. This happens a lot in sexual offenses where the defendant has a reasonable fear that the jury is not going to listen because of the nature of the case. And so they feel like the judge may be more neutral, more unbiased. And so I want to waive my right to a jury trial with the judge to decide, because in theory, the judge is going to make a decision based only on the facts and not emotion. Thirdly, the defendant may waive his right to jury trial if the case is particularly complex and the defense's strategy hinges on very complex legal matters for which a jury may not understand. And so rather than attempting to get the jury to understand the complex legal matters and technicalities, I'm just going to get a judge to make the decision because the judge, being an experienced attorney, will know that. Either way, whether I'm having a bench trial or I'm going to have a jury trial, trials begin with opening statements. Now, all an opening statement is what each side expects to show. So the prosecution has an opening trial, his opening statements, he tells the jury, here's what I expect the evidence to show. The defense, their opening statement, are going to do the same thing. Now, the defense does not have to make opening statements if they don't want to, because remember, Fifth Amendment, protection against self-incrimination, which means the defendant and his attorney don't have to say a thing, don't have to say a single word other than guilty or not guilty during arraignment, don't have to say anything, don't have to present any evidence, don't have to make any statements, don't have to do nothing during the trial. And so opening statements includes in that, don't have to do nothing. So I, as the defense, I can either make my opening statement right after the prosecution does, or I can elect to wait until the beginning of my part of the trial. So I can delay. It's like in football. If I win the coin toss, I can elect to kick, I can receive, or I can defer to the second half. And the defense can also defer to the second half, just like in the NFL. After opening statements, the prosecution always goes first. They present what's called their case in chief. This is where they present their evidence. Here's all the evidence I have to prove that this guy committed the crime. They have to prove two fairly simple things. First, they have to prove corpus delicti, the body of the crime. In other words, they have to present enough evidence to establish that, yes, a crime happened. Corpus delicti, body of the crime, and it's often, you see it on the TV shows, the movies sometimes, that so without a body you can't get prosecuted. And sometimes that's true, because with a murder case, it's really hard to prove murder if you don't have a body, because as long as there's no body, the defense can always say, dude ran away, dude went to India to find himself. There's always going to be reasonable doubt if you don't have the body in the murder case. It's a very difficult thing to overcome. So, of course, prosecution during the course of their case in chief have to prove that the crime actually happened. Sometimes that's super simple. Again, murder, dead body. Yep, there's a dead body with 47 stab wounds in it. Obviously, a crime happened. Then you must establish a prima facie case. Again, prima facie case is two parts. Part one is the corpus delicti. You have to prove that a crime has been committed, and you have to prove the defendant probably did it. If the state doesn't put out enough evidence to at least prove a prima facie case, when the defense asks for a motion of acquittal, they will, the judge may grant, is more than likely than not to grant it. And for this reason, the defense is almost always going to ask for a motion for acquittal. When the prosecution rests their case, the defense got motion for acquittal. Prosecution didn't make their case, didn't make their prima facie case, and most times judges go, yes, they did. They established probable cause, but the defense is going to try, if for no other reason than to come back later on appeal and say, yeah, judge made the wrong call here. All right, speaking of evidence, so prosecution, case in chief, they're going to present their evidence. So what is evidence? Evidence, of course, is anything presented to the court, presented to the judge, that tends to prove the guilt or innocence of the defendant. In the case of prosecution, it's anything presented to the court that would show that the guy did it. Two types of evidence. There's direct evidence. Direct evidence is anything that directly proves or disproves that the defendant committed the crime. Direct evidence are things like eyewitnesses. Yep, I saw him do it. Videotape evidence. I got him on video doing it. Again, anything that can directly tie the defendant to the crime or directly prove the government's case. Then you have indirect evidence. Indirect evidence is any evidence that requires interpretation. This is the majority of evidence that you see on the TV. DNA evidence, fingerprints, any scientific evidence, gas receipts, anything that indirectly ties the defendant to the crime. Some professors and law school profs like to explain indirect evidence as any evidence that has to be explained. Direct evidence, no explanation required. Guy gets on the stand and says, I saw him do it. Videotape, you see the defendant commit the crime on tape. Doesn't require any explanation. Indirect evidence requires explanation. And the crazy thing is, in our court system, that with scientific evidence, when you put the crime lab guy on the stand, every time you have to explain the science. So you've got to explain DNA to the jury and then show that the DNA evidence links the defendant to the crime, or the fingerprints, or any of that. I think it's hilarious. That's how I know anything at all about DNA, is because I sat in a capital murder trial with a crime lab guy on the stand and got DNA 101 during the trial. All evidence, whether it's direct or indirect, must have probative value. In other words, probative value means it provides useful information relevant to the case, and the judge gets to decide that. You see on the TV all the time, or the movies, objection, relevance. That's one side saying that evidence doesn't have probative value. The judge then makes a decision, yes or no. That judge's decision then can become preserved error for appeal. Let me talk a little bit about witness testimony while I'm talking about evidence. Now, witnesses, all evidence must be presented by a witness. So even if I've got a videotape, I got to put somebody on the stand, probably the guy who made the videotape. I have to establish, this is a videotape. Yes, this is what I recorded. I can establish the video is real through that. Then I show the video. Right? But testimony, let's talk about that. Testimony is oral evidence offered by a sworn witness on the witness stand during a criminal trial. The examiner, whoever put the person on the stand, must first establish the identity of the witness. You see it on the TV and the movies. State your name and address state your name and address, or state your name and occupation for the record. You're establishing the identity of the witness, and you also have to establish the relevance of their testimony. So if I put a police officer on the stand, I do that by asking the officer to identify himself and state his occupation. Hi, I'm Officer Bob Smith at Nacogdoches Police Department. Next question would be, on such and such a date, did you investigate a crime? Well, yes, I did. And then he explains, and that's how you tie the witness's testimony to the offense. You do that with scientific evidence. You establish the identity of the person. With expert witnesses like scientists, when you're establishing their identity, you must also establish their bona fides. You must establish that they are qualified to testify about whatever that scientific evidence is. And then you have to have them testify about the science. Then you can introduce the evidence. So there's a process when questioning witnesses. So one side or the other, depending on, so we're talking about the prosecution's case in chief. Note that this is reversed if it's a defense case in chief. So the prosecution puts a guy on the witness stand. They establish their identity, their relevance testimony. This is called direct examination. And direct examination is conducted by whoever put the individual on the stand. In direct examination, you cannot ask leading questions. So you cannot ask, so on October 7th, blah, 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 did you investigate the murder of so-and-so and so-and-so? That's a leading question. A leading question is any question in which the answer is implied. And so instead, if I put the guy off the stand, I could say, so were you on duty in the night of blah, blah, blah? Did you, during your shift, did you investigate any, did you investigate any murders? And then the guy would talk about it. But I can't suggest the answer in my question. When I'm done, I tender my witness, tell the judge I got no more questions for this guy, and then the other side gets up and I do cross-examination. Now, during cross-examination, in other words, it's not your witness, you can ask leading questions. Now, isn't it true that blah, 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 blah? Yes or no questions. Only those type of questions, those leading questions, can only be asked on cross, not on direct. Now, after I'm done with my after the defense is done with their cross-examination, the prosecution can redirect, so they get a second chance to kind of firm up whatever holes the defense shot in the witness's testimony. Finally, one thing that cannot be testified about is something called hearsay evidence. Hearsay evidence is something that's not based on personal knowledge of a witness. And so, if I know that Bob killed Jane because I overheard Bob telling somebody else that he killed Jane, that's hearsay. For me to testify about something, I have to have observed it myself directly. Okay, none of this, well, he told me that he said, she said stuff is hearsay and doesn't work. There are exceptions to that, things like excited utterances and dying declarations, statements against self-interest, all sorts of things that you'll learn about in your criminal procedure courses. Once the prosecution has completed their case in chief, they rest their case. The defense then gets to make their case in chief. That may start with opening arguments if they defer to the second half, as it were. But they repeat the whole process. They get their opportunity to present evidence. They are not required to do so. The prosecution can stand up and say, the prosecution rests. The defense can stand right up and say, Your Honor, the defense rests. And that'd be it. Case goes to the jury. Remember, because of the Fifth Amendment, the defense isn't required to put on in a case at all. And that is a legitimate trial strategy for some defense attorneys, that they make their case during cross-examination, during the prosecution's case in chief. So when it comes around to their turn, maybe they don't have any witnesses to put on the stand. Maybe they have no evidence to present because they presented their case during the prosecution's case through their cross-examination. Now, your textbook, I think at this point, covers some criminal defenses. We covered this early in an earlier unit. I'm not going to repeat. You learned about alibis and justifications and excuses and procedural defenses in an earlier unit. And so we're not going to talk about that here. Once the defense rests their case, then you have closing arguments. This is an oral summation of the case presented by both sides. Basically, both sides review the evidence that was presented. It's almost like what they teach in speech class, where they say, okay, tell them what you're going to tell them, tell them what you told them. Trial process, opening statements, here's what we think the evidence is going to show. Then you present all your evidence, you have a closing argument, and you say, okay, here's what the evidence showed you. So you review for the evidence. The order of closing statements varies by state, but most states, the defendant goes first, and the prosecution gets the final say. In some states, in the federal system, the defendant gets to make a rebuttal after the prosecution's closing statements, but that's not every state. At that point, then the judge gives the charge to the jury, where the judge gives instructions to the jury, explains the law, explains reasonable doubt, tells the jury, you know, okay, here are the elements of a crime, here's what you must say, you know, to vote, you know, say this person's guilty. Here's what the prosecution had to approve beyond a reasonable doubt. He was playing reasonable doubt. You give them all the instructions, and then the judge sends the jury to deliberate, and eventually the jury comes back with a verdict, probably, and that's what we'll talk about in the next segment of this lecture.